Attorney Miller, are there any kind of myths out there about estate planning that you would like to address here?
Uh, Most people talk about intestate law. What happens if you don't have a will? It is a bit of a myth that if you don't have a will, everything goes to the state. That's not
I have
true.
heard that myth.
Yeah.
Okay.
That's not true. What if you don't have a will? The law kind of makes a will for you. They look to see if your parents are alive, if you were married, whether you have kids, and they set forth who gets what. And if you don't have your parents aren't alive, you never had kids, or they're not alive, and you're not married, then they start looking for brothers and sisters, and then if not aunts and uncles. And there's a priority list of only if they can't find anybody else. They have looked up and down your family tree looking for anybody. Will revert to the state. I know.
Another myth.
Yeah, I mean, and that insinuates that okay, well, I don't have to do a will. Well, don't assume that the law has it right for what you want to do.
Yes.
So, really, wills, by the way, typically are $200. It's not. Again, I'm not saying that's chump change, but at the same time, it's not overly expensive.
One of the things, thousands of dollars.
Yeah, no, and even when I'm doing a will with a significant amount of trust work in it, it still is. I don't know if I've done one in recent memory. It's ever been over $1,000. It's usually instead of 200, maybe it's 300, maybe it's 400.
Okay.
So it's inexpensive. And one of the things I offer, and I'm not trying to make this an advertisement, but one of the things I offer is that if you're a client of mine, and by virtue of doing the will, you are. As long as I'm in practice, you can come back to me and revise your will for free. So down the road, when your brother Joe is no longer your friend and you want to write him out the will, come on over. We'll write out the will and take care of it. I've heard some people say, well, the law is that in order to have a valid will, you have to have two valid witnesses and a notary. And that is required, but there is a backup plan to that. And for example, if you're at a restaurant and you feel the heart attack coming on and you want to write down quick what your wishes are, you can do that. You can take out a crayon on a cocktail napkin and write out, I give everything to Larry Miller, and sign it and date it, and that's a will, right? The only catch is when you have that cocktail napkin and you want to probate it, and probate's the process of and that brings up another myth I want to end with. But probate's the process of going to court, registering your will, and then following the terms of the will. That when you do that, you have to, since you don't have two witnesses as a notary, you'll have to come up with two witnesses that, one, have reason to know what your signature looks like, and two, can testify that that's your signature. And they typically can't be people in the will because they're biased, right? So it's better to have a will with, particularly, you live to 150 years old. People may not recognize what your signature looks like anymore, and less people know what your signature looks like. So getting a will done is far more appropriate. It's easier, so it's doable. And the last myth that I hear a lot of people about, this comes into the whole living trust issue, is that the probate process is so time-consuming and so full of taxes and requires so many lawyer expenses that you want to avoid probate. I'm not an Arizona lawyer. In Nevada, I've heard this being an issue. Those are West Coast states, and I don't know a lawyer there. But I can tell you from the East Coast, and I'm licensed in Pennsylvania. I've also dealt with states in New Jersey and Virginia. Those states, probate is not overly expensive, and it's not overly time-consuming. I'll address just Pennsylvania for right now, but New Jersey and Virginia and Maryland are all similar. But in Pennsylvania, you pay a fee based upon the size of your estate. You have done that anyway when you hand in the will, as far as a fee for them to do that. You're never required to hire a lawyer to probate a will. You can do it on your own. But most people don't know the process, and they hire a lawyer to do that.
And what are the fees range? They come out of the estate, right? So.
The state pays them.
Okay.
Again, there's a graduating scale. Let's say typically $500 to $600 of state money, if there's a substantial estate, would be paid in fees. A lawyer fee, the typical lawyer fee that I've ever seen dealing with whether it be some kind of a trust or a will, is 5%. That's really being cut back now by courts who don't approve of charging so significantly in 5%. There is a chart that's available that kind of dictates what the Attorney General would like to see. And it's 5% on the first 50,000, 4.5% on the next 50,000. It kind of goes down.
Yeah, that's nice.
When you hire a lawyer,
they should do that with real estate agents as well.
I completely agree.
All my fellow real estate agents are going to come after me now.
Well, you know, sometimes and I don't mean to say anything bad here, but a lot of real estate agents, their fee is negotiable. So if you're doing something that's a lot easier than not listing it, they're kind of making a transfer and what have you. You can negotiate that. The same thing with a lawyer. When you hire a lawyer to handle your estate, it's negotiable. So a lot of times what I like to do is I like to sit with the client and say, look, let's talk about what needs to get done. So tell me what's in the estate, and we can sit there and I'll do an estimate on how many hours it is, and I'll offer you a flat fee based on that. Typically my flat fee depends on the size of the estate, but typically my flat fee is between 1% and 2% for the total thing. And so I give you the offer.
Seems reasonable not to have to deal with all the headache and I get a little stressed out when I think about courts. So
and lawyers, what they're doing, and they kind of run the whole thing through, but it has to be a reasonable price. So when you have a will or when you have an estate, shop around maybe a little bit, find someone you want to work with, someone that's more affordable. If someone that has experience in the field, we all kind of know what the law is. I think what's separating one from the other is price and personality. You're not going to. I tell people, when you're going for a surgery, you're not going to shop for a doctor based upon the cheapest one. You want someone with experience to do a good job. Lawyers are kind of the same way. I think if you're looking at experienced attorneys, the experienced ones are all kind of the same. We know what we're doing. The personality can be a huge difference. One that's going to work with the beneficiaries, answer their questions, help you through the process. They're worth more. Trust me on that, because you get in the process and you have a lawyer that's just doing everything for you. It's unavailable by phone when you call. It's frustrating, and usually anger comes in. You don't know who am I getting ripped off, or is the numbers? But someone that's willing to work with you a little bit is worth a little bit more. So when you have experience, maybe they're all the same, but price is important. But trust me, if someone's doing it at 0.5%. And versus someone that's doing it at 1.5%, but the 1.5% is easy to deal with. They talk to you. It really is. I had so many people that have fired their attorney at some point out of pure frustration, ended up hiring us because they were so angry with the attorney and that he wasn't doing anything and it had gone on for more than a year. No communication. It's worth a little bit more to have someone that you know what they're doing.
I agree.
But the probate process, I get off the subject a little bit, but the probate process is not expensive. It's a check, and there's a couple of forms that they require, which, by the way, living trusts and other things require the same thing by Pennsylvania law right now. So you're not saving on attorney's fees. You're certainly not saving on any taxes, and you're not saving on the process because the probate process now requires the same thing for trusts as they do for wills. Usually, that means the living trust isn't valuable to you anymore, because a lot of times we used to have with the turn of the millennium, we had a big problem because there were companies selling living trust to you. They sell them at $2,000, $2,500, saying the probate process is so scary that you want to avoid it. It's in Pennsylvania, and it's really not.
You still want a trusted advisor to help navigate you through it. Probably most people,
but usually a will, maybe a power of attorney, gets you the same place that this $2,500 living trust was. So again, my overall advice would be, find an attorney you can talk to. It's not expensive for estate planning purposes. And assuming that the law, or assuming what a salesperson is telling you or what a friend's telling you, it's not safe. Go talk to someone who knows what they're doing. It's well worth the time.
Yeah. Thank you so much.
Very good.